Roosevelt's great justices faced some extraordinarily challenging and difficult issues in their time together, but none was more difficult, more challenging, or more complex than the problem of racial segregation. Under the U.S. Constitution, the federal government did not necessarily possess the capacity to block the states from engaging in segregation locally. Perhaps Congress could have passed a law that prohibited such segregation, as eventually it did do, but in the Senate, the filibuster, created to protect minority rights, had the effect of enabling the southern states to block any civil rights legislation time after time. The president, acting unilaterally, could desegregate the military, but could not desegregate the South. That left just one branch of the U.S. government with the capacity to make this fundamental change, and that was the Supreme Court. The justices in the fall of 1952, who heard the first oral argument in the case that would become Brown against the Board of Education, were deeply divided. When they entered the conference room to discuss a challenge to the fundamental structure of segregation, 4 of them were justices who came from the segregated South. Of those 4, 3, including the Chief Justice, Fred Vinson, declared openly that they would never vote to end segregation, which was fundamental to the Southern way of life. There was just one single exception to that, and remarkably, it was Justice Hugo Black, the one who had come onto the public scene by joining the Ku Klux Klan and riding their coattails, or maybe I should say their robe tails, to become a member of the United States Senate. Black understood that this was his moment to redeem his history of racism. He had been deeply and profoundly shamed by public revelations of his Klan membership. If the Supreme Court, with his vote, were to end segregation once and for all, he knew he would cleanse himself of that stain. He told the other justices in the privacy of the conference room that in his opinion, they ought to strike down segregation because the Constitution as originally interpreted required it. Black took his new judicial philosophy of originalism and in the greatest moment for originalism ever, told the other justices that the only true meaning of the 14th Amendment was to eliminate racial subordination, and segregation was obviously an example of that. The other justices were not all prepared to bite. This created a big challenge for Felix Frankfurter. Frankfurter considered himself a race liberal. He had been a member of the National Advisory Board of the NAACP. He had been a founding member of the National Advisory Board of the ACLU. In his mind, segregation had to go, even if that contradicted the value of judicial restraint, in which he firmly believed. But Frankfurter had a caveat. He believed that if the Supreme Court was going to do something so radical, such an extreme act of judicial activism, it needed a unanimous court to do it. He believed a divided court would lack the legitimacy. Yet he could not convince several of the justices to vote to strike down segregation. In consequence, he adopted a strategy of delay. He asked the other justices not to decide the case, but just to think about it. And they thought, and they thought, and they thought. And the case sat on the court's docket for a full year with nothing done about it at all. At the end of the Supreme Court term, the next spring, the justices relisted the case for another oral argument in the fall of 1953. Summer passed, and there was no progress. Then, in September of 1953, Chief Justice Fred Vinson suddenly died of a heart attack. Frankfurter traveled from Cambridge, Massachusetts, where he used to spend his summers, all the way back to Washington, D.C. for the funeral, and he was met at Union Station by his former law clerk, who was working at the time in the Department of Justice. Frankfurter grabbed his former clerk by the arm and said to him, "Phil, this is the first evidence I have ever received that there is a God." The death of Vinson opened the door for the nomination of Earl Warren, the governor of California, as Chief Justice. Warren had a completely different view than the segregationist Vinson, and one by one, he began to knock off the dissenting members of the court, convincing them that they must sign. By the end, just one justice remained who was unwilling to join the would-be unanimous holding in Brown against Board of Education, and that, remarkably enough, was Robert Jackson. It wasn't that Jackson was a racist, and it wasn't that Jackson felt that segregation definitively had to be preserved. Rather, as a pragmatist, Jackson wanted the court to explain openly to the country why it was that segregation, which had been perfectly permissible under the Supreme Court's interpretation of the Constitution under the case of Plessy against Ferguson, was now being changed, altered, and overturned. Jackson wanted to write a separate opinion, which would be attached to the court's opinion, which would say that circumstances had changed and that African Americans who had previously been in a reduced state by virtue of their slavery experience were now educated and therefore capable of being treated as full equals. The other justices, in particular Warren, thought it was a terrible idea to offer any explanations. Not only did they want unanimity, they wanted unanimity behind the opinion for the court that Warren had written that would not imply that the earlier decision had been superseded for any other reason than greater knowledge of the effects of segregation. Jackson might have held out indefinitely, but he had a heart attack. And then, in the hospital, he was approached by Warren, who came to visit him, brought him the draft of the opinion, and essentially told him that he would not leave the hospital room until Jackson agreed to sign the document. Jackson did it, and the court unanimously decided the case of Brown against Board of Education. Jackson himself rose from his hospital bed against doctor's orders and went to the Supreme Court for the dramatic and famous announcement of the outcome of Brown against the Board of Education. 3 months later, Jackson would himself die of a heart attack. The history of the Supreme Court under Roosevelt, the Roosevelt justices, then reached its symbolic close. Never again would those justices together achieve an extraordinary new result. Never again would they fight it out the way they had so viciously done. But the first act of the Warren Court, Brown against the Board of Education, what many people consider the high point of the Supreme Court, its greatest moral moment, was also the final act in the history of the Roosevelt Court. The lesson of these justices is a complicated one. They were justices who cared about results, sometimes too much. They were justices who saw their jobs politically, not neutrally. They were self-made people with real-world practical and political experience. They were also not people inclined to compromise. Their mutual dislike, which rose often to the level of detestation, was sincere and total. But in their battles, they developed the beliefs and values that made their constitutional philosophies coherent and therefore made them great justices. They explained why they were doing what they were doing. They explained their reasons for it. Under them, the Supreme Court was controversial, but it was also a central American institution. And when they left the court one by one, they left behind a constitution that they had fundamentally altered and changed, the modern Constitution, which we can still recognize when we look at the Supreme Court today.